Law Talk with Nick Maruchak, thanks to MKI Legal, your trusted employment and family lawyers.
I fought the law and the law won. I fought the law and the law
Right, you have 27 minutes of free legal advice, and I suggest you get online and ask the questions because it's not cheap. It is not cheap to talk to a lawyer because they've got so much information. 0487 999 882 if you'd like to keep yourself a little bit, quieter, on the quiet, but talk back. Remember, we've got the prize of the day for our caller of the day, 133 882, and talking to Nick in person is always a better way to paint the picture for him. How you going, Nick?
Great, Chrissy.
Running up to the end of the year nicely?
Yep. Christmas spirit is up and running, and we have the Christmas decorations in our office.
You have a naughty elf?
Oh, the naughty elf, yes. I haven't started that yet, but the kids do love that.
Because they have their legal requirements for the naughty elf, places it can go, can't go, has to sit with. Anyway, let's get Terry from Madley has jumped straight online. He said, yep, I need to speak to you, Nick. So, Terry, hello and welcome.
Yeah, good morning. Thank you very much. Nick, I'll endeavour to surmise this as best as possible. We built a house 5.5 years ago. We've just recently undergone the issues of the repiping issues that's currently in store with one of the major builders here in WA with all their IPlex issues. And it came to our realisation that the builder didn't meet certain obligations with installing insulation when the house was first built. And we were only just made to notified of this because of all the ceiling was cut open for the repiping. And we're just trying to understand the contractual obligations now after 3 years, even though they've said they'll undertake it. But we're just at breaking point now with our house being a construction site for the last 8 months. And I don't think we could do this again.
Okay. So there is a process. You can go to the Building Commission. So the Building Commission falls under the Building and Energy, WA. So Department of Commerce is Department of Mines and Industry regulates all that. There is a 6-year period to make this complaint. So you said 5.5 years ago that house was built. So you're very soon going to run out of time because if there is faulty or defective work, that's where you can make the complaint as long as you meet certain guidelines, like the house is no more than, I think, 500,000 is the max that you can do. And then they can order rectification. Have you gone and pursued the Building Commission process? Yeah.
We've lodged a couple of areas, but, the builder has come back and said, we'll go through and install it. But after 8 months of our house being a construction site, and we've just been caught up in a day-to-day living, and we're just getting tired of going through this. I don't think we could do it again. If they came back and said, we've got to rip your whole ceiling open now to install the insulation. Okay.
So because are they taking too long to complete this work? Because there is also an avenue to get compensation, right? So with the Building Commission, you can actually, if it doesn't resolve, you can kick on to State Administrative Tribunal, and that's where you can get formal orders for compensation for loss. And this is where you might get compensation for, say, reaccommodation or anything that arises from that. So how far along are you in the Building Commission? Because you want that complaint lodged so you don't expire, because once you get over the 6 years, it becomes a lot harder to do anything. So has that been lodged with the Building Commission? Have you got that complaint on the file?
We formally lodged the notice to put this to the Building Commission, to the builder.
Yep.
On that 14-day period that you're, just as part of the
you have to do it.
Guidelines.
Yep.
Yeah. So we've got a few days left to go on that, and then we'll lodge it, and then we can take it from there.
Yeah, because
so we're ready to lodge something. Yeah.
I'm just really concerned because once that 6-year period from when practical completion finishes expires, then you're out of time, and that could put you in that could restrict the remedies. And so you're saying that, it's been 8 months already that they're trying to fix it. It hasn't really resolved adequately. So you want to give them a call and just have a chat to them, because it might, you just really want to watch that 6-year period, and you might want to start lodging it, because then your claim's in the system, and
Yes.
and that's where you might also seek potentially, compensation for the outcome. And you can go through that yourself to some extent, and you save yourself on legal fees, and maybe see a lawyer here and there just for an hour or two, just to get some advice along the way. But
yeah, perfect.
I would consider that.
Our main concern, Nick, our main concern also is that if this has happened to us, how many homes were left in the same predicament by this builder that's going through a couple of class actions as we speak?
And that's where the home building insurance, all builders have to get this indemnity insurance, which means if they go bankrupt or if they don't complete the work, then the insurer will step in and cover you for about $250K to repair what they left. But that only happens if they abscond or they go under. So you ask them to see that insurance policy as well. That's your right. So make sure you ask for make sure they do have it. If they're reputable, they'll have it. But so you do have a bit of a protection there. Sometimes the 250 is not enough to cover everything, and that's where you might be out of pocket. And if it's a big enough problem, the state government hopefully might step in. But if it's not, then
all right.
Yeah. Thank you for that. Yeah, thank you very much.
Good on you,
Good
buddy.
luck.
Well done, Terry. And you could be in line for our caller of the day today. If you'd like to join us, 1333 882, or text us 0487 999 882. And talking about builders, young Nick, St Nicholas, keeping in the theme with the name. One of the topics that you wanted to have a chat with us today about was noise enforcement laws, and construction noise is a big one for people. When you go over the bridge in particular into Fremantle now, I look at those poor people in that apartment building next to it and I just think, oh my gosh. And I know that in the end it's going to be fabulous for all of us. Nevertheless, do they have some legal leg to stand on in there? They must. The noise and everything from there must be terrible. Are there laws enforcing when and the builders can and can't be building? Because they're working at night, aren't they?
Yeah. So there is something. The noise is regulated by something called the Environmental Protection Act, and under the Act, the regulations assign noise levels for based on land use. So for residential areas and stuff like that, you have kind of a maximum noise. But construction is treated in its own special category. So there is regulation that does apply to construction. And specifically, that's under the Environmental Protection Noise Regulation, Regulation 13, for anyone interested in that specifics, but probably not. So the long and the short of it is, when it comes to construction, the general rule is you want to be able to, most construction, where possible, should be between 7 a.m. and 7 p.m. And Monday to Saturday. So nothing on a Sunday, nothing on a public holiday. So they can, so sometimes they're allowed during that period to exceed the maximum level if the work follows the Australian standards. The Australian standards, they have their standards that are guide to noise and vibration control. So, and if they use the equipment in the quietest reasonable, they use equipment that is the quietest reasonable available, right? So that's kind of the requirement they have to do. If they want to go outside these between 7 a.m. and 7 p.m., say evenings, on Sundays or public holidays, then there's extra hoops they have to jump through. So they have to kind of notify neighbours, and they have to show that it's absolutely reasonably necessary to work, in the evenings and on Sundays, due to a variety of reasons. They have to also submit a noise management plan as well. They have to lodge that with council, and in the plan they have to kind of predict the noise level. They have to kind of account for what's being done to reduce it. They have to even have a complaint process in place to how they handle neighbour complaints. So highly regulated. And so when these builders are, they have to kind of use the equipment that's the most quietly reasonable available. But, if you're doing high impact things.
So can I make as much noise as I want on Sunday on my home at the building site? Can I crank out the...
You're not constructing anything, are you? So,
I might do. I might suddenly just get a rush of blood and YouTube how to build a large wall. I don't know.
Well, because these apply to construction regulations. So, so you need the
home renovations?
Yeah, home builder. So if you get the home building license and stuff, then you have to follow all these, I would imagine, as well.
Imagine if I'm out in the backyard and I want to smash a wall down and I start doing it at 7 o'clock at night. because it's summer, it's been hot, and I've gone, sod it. I'll do it late in the evening, and it's going to take me 2 hours under flood rights. And Mr. Smith next door and Mrs. Brown on the other side have both gone, what legal recompense do they have?
Yeah, so basically under this Environmental Protection Act, and this applies to your example and also applies to house parties as well.
Oh, house parties.
Yeah,
While I'm knocking down the wall, I could have a house party.
No, it's so basically there are environmental officers that have authority that are given authority under the Department of Water and Environmental, the Department of Water and Environment Protection. So they get these authorities. The environmental officers can go in and give you a fine. So and police officers also have additional power. Say if someone's having a house party, they can tell them to order them, give them a direction to stop the noise. And if they don't follow the direction, then that's an offence. They also have the ability to take away any noisy equipment. So in your case, if you're banging down things, they're going to take your
hammer,
your jackhammer, whatever you're using. They're just going to confiscate that and take it. And worst case, they'll prosecute you. Either local council or the government will prosecute you.
Imagine Mr. Brown and Mrs. Smith's sense of satisfaction to see my hammer walking out the door.
Yeah. So the police officer can take your hammer.
Cool.
They'll come in and they'll say, stop the noise. And if they think you're not going to follow them or they've given you this direction, you haven't followed it, then they take your hammer and they'll confiscate it. You can get it back, but you have to pay for the holding costs. And if you don't pay the holding costs, they'll destroy your hammer. So your hammer's gone.
Thor wants his hammer back. We're going to go to a quick break. And when we come back, we'll go to some more of your calls. Veronica from Greenwood, stay on the line, 1338 882. Jump in and ask your legal eagle questions. Veronica from Greenwood has picked up the magic telling bone, 1338 882, and given us a tinkle to talk to our law expert, Nick from... Nick, what's the name of your business? Sorry.
MKI Legal.
MKI Legal. I just looked at it and thought, I think my eyes are playing tricks on me. All right, Veronica, what would you like some help with?
Nick, last week there was a dad that rang up about being guardian and administrator for, I think, a daughter or so with disability and not having to do the finance reporting. Did you find out if that's a possibility, that you don't have to do the finance reporting, and why it was taking so long for him?
Yes, I did. I had a chat with him after, and so basically, if you're appointed as administrator, you have to submit accounts to the public trustee, and the public trustee will examine the accounts, and then they'll say this is allowed, this is not allowed. If they say something's not allowed, then you have to compensate the estate or the person the account. You have to put it back in. So that's a safety measure in place. What this caller from last week did is when he was seeking the administration for his disabled daughter, who's an adult, he asked the commission member said you should apply to seek an exemption. So he applied, and he was waiting a long time for the commission to make a decision. So he's in a bit of a pickle because there's not much you can do if the commission's taking a long time. So so you can be relieved from reporting to the public trustee if the State Administrative Tribunal exempts you from doing it. So obviously that application has a good chance of success because it was suggested by the commission member for him to do that. The issue here is because that's taking so long, what one avenue available to him is to notify the public trustee, to tell them, look, I've made this application, the commission's taking ages, just to let them know that you won't be reporting it, and unless they have a problem with it, then you will start reporting. And if a commission member is taking so long to make this decision, there's not much you can do. You can you can complain to the commission, or you can go to the WA Ombudsman and stuff like that. But that really unsettles the cart. So yeah, that's a bit of the background of that. Is there anything that that you would like to comment on about that?
Well, yeah, I'm sort of going through the process, and I hadn't come across that you could apply for an exemption. So I thought I'll have a look into that, and I'm really lucky that I got back in the car and you were on, because I wrote myself a note, but there we go.
Yep.
Yeah, so I just thought I'd see. So that it is possible.
Yep, section...
It's not for everybody. Was his circumstances unusual or different?
Well, for me, it was his child that he's been taking care of for the last 20 years. So that probably has a stronger chance of getting through versus someone who is not related.
Okay.
So that probably really strengthened it. But look at Section 80 of the Guardianship Administration Act. That's how you apply. maybe have a look at some past cases as well, because no doubt they'll be reported. So if you go, just put Section 80 of the Act and see some of the criteria that take into account.
Okay, no, good. I'll have a look through there. Beautiful. Thank you very much.
No worries, Veronica.
Thanks, Veronica. There is time to take one more call, 133 882 133 882. I've got 4 minutes up my sleeve left to talk with Nick. Nick, one of the other things that you wanted to raise today was credit reports framework. So what actually goes onto a credit report?
Yeah, so these are basically like financial resumes. They're used by banks, telcos to decide whether to lend to you or not. And so you've got your repayment history. So whether you've made the payments on time, that will last 2 years on your report. Whether you've made a financial hardship application. So if you're going through, say, you lost your job, you're going through a divorce, you can apply for financial hardship relief, and the bank has to do certain things to look after you. Fortunately, that's only there for 1 year, so that's good. Okay. Any defaults you've made over $150 or more that are overdue for 60 days or more goes on there, and that lasts for 5 years. Other stuff is like court judgments, and the credit reporting agency can use publicly available information as well. So and the credit score can go on, but a credit score is just an internal algorithm that these reporting agencies use. So the tips I'll give to people is, because these are really important, you can get a free report every 3 months, and you just write to them and they have to give it to you.
Okay.
And if you've been refused credit, you can get another free report if you've been refused credit in the last 90 days. Really important thing, if you're a victim of identity theft, write to the credit agencies and they can put a freeze for free on your credit report, so no one can. So that will prevent further people applying for dodgy loans, right? Because then if you're a victim of identity theft, they'll apply for a loan. And what happens is the bank will go request a credit report, and then they'll see the freeze, and that will stop anyone getting loans in your name. And you can keep extending that after the 21-day period. So it does make it harder to get legitimate credit, but that's something you should do if you feel like your identity's been stolen, to prevent.
You've got 30 seconds, Nick. Wrap it up. What's your last tip from Nick? Okay.
Well, just the people who can't access it is only a limited amount of people. So real estate agents, landlords, employers can't request your credit records. So that's also good to know. And if you're upset about your credit, ex-husband can't. And if you're upset about anything and you approach them to correct a mistake and they haven't fixed it, you can go to the Australian Financial Complaint Authority for free to remove it as well.
Fabulous. And if not, we can give you a ring. What number are we calling to give you a call?
9470-2777.
Nick, thank you so much for coming in today. Nick Murchak. Well, go on, say your last name again.
Murchak.
I'm going to get it right 1 year. From MKI Legal. You're listening to 882 6PR.